Hello and welcome. We're back. Disability Law Show is back with you for the next half hour. John Scholes, James Fireman from disabilityrights.ca. Always off the top, the contact information. Consultations are free. By the way, phone number is 1-855-821-5900. Reach out at help@disabilityrights.ca. Okay, lots to cover over the course of the next hour or so. Stick with us, or half hour anyway. Don't be pressured back to work from LTD, protecting your rights. That's the main topic in the second segment. We'll get to that. We got phone calls coming up. We got emails. We got questions. We got answers. It is a big show. Big show. James, you always start us off with a little something. What do you got, pal?
Well, I'm really glad to be here. We're going to talk about a lot of issues that are going to be really helpful for anybody, wherever you are in the LTD claims process. But I want to start with a topic that has gotten an awful lot of attention in the media, and that's AI, artificial intelligence. Now, artificial intelligence is becoming more and more ingrained in our day-to-day life, and in some ways, that's great. It can be helpful in many, many ways. But from a legal perspective, it's pretty dangerous. And that's especially true when we're talking about long-term disability cases. So the reason this is coming to mind is I was actually just sent a case that was released quite recently, where a lawyer had submitted materials to a judge in a motion, which is a court process. And the materials used AI to generate what's called a factum, basically an argument of law, and had essentially come up with cases that did not exist. It hallucinated these cases into existence that were supportive of the lawyer's client's case. And the judge got the materials and went through these cases and realized that these don't exist. They're not actually case law. They're nothing that the court would ever need to rely on, obviously. And it was quite embarrassing for the lawyer, and it's become very public. So in that context, obviously, AI can be very dangerous. Now, that was not an LTD case. But the reason I'm saying LTD is particularly dangerous when it comes to AI is because we've also quite recently been getting many clients who have contacted us after having first used AI, ChatGPT or other AI products, in order to get an initial assessment of what their long-term disability case was like, what it might yield if they were to pursue litigation, whether or not they had a strong case, that sort of a thing. And then either being told that they have no case or a great case, they contact us, and very often what the result is I've taken a look at it, and I can tell very quickly that what the AI has told them is, in fact, incorrect, and often by a wide margin. Now, why am I saying that it's particularly bad for AI? Well, AI relies on whatever you feed into it, whatever is publicly available. And when we talk about long-term disability law, if you've watched the show before, one of the things we talk about is what's the likelihood of your case going to trial if you have a long-term disability case? Because that's something whenever anybody starts the process, whenever anyone engages a lawyer to start litigation, especially with respect to LTD, they want to know, is this something that's going to wind up in court? And it is exceedingly rare for an LTD case to wind up in court. It happens maybe 5 or 6 times a year. Maybe 5 or 6 times a year, there's a reported decision from long-term disability. And that's not our firm. That's not in Ontario. That's across Canada.
Wow.
It is just so unusual for long-term disability cases to wind up in court. And because of that, AI has very little to draw on when it comes to trying to figure out what is an LTD case and what is a court likely to do with it. The reality is that all of us that practice in the field only have a limited amount of information to work with, so what we have to rely on is our expertise in dealing with these cases day to day in mediations and thousands of other instances that are never reported publicly that AI would never have access to. And because of that, if you're relying on AI in order to assess your claim, particularly a long-term disability claim, you have no ability to be confident in what the result is, which is why, of course, we say if you're watching and you have an issue and you're concerned about whether or not you have litigation, what your long-term disability insurer is asking you to do, whatever the case may be, give us a call. It's a free consultation. And if you're nervous about making the call, well, guess what? We have another product that's available to you. It's not AI. It is something that you can use independently, though, on your computer. It's called the Pocket Disability Lawyer. And I think I'm just leading right into our next topic.
You got it. PocketDisabilityLawyer.ca is exactly what James is referring to. You punch in some key information, a bit of a drop-down list, and it'll say, yeah, you should call James, or nope, don't bother calling James. Don't waste your time. It's that simple. It's free to use. AI thing, to your point, it doesn't it's okay, like you said, with ones and zeros and information put into it, but it doesn't have the nuance that a lawyer does. And plus, it's borderless, so it may be pulling information from New Zealand and America and everywhere else, right?
That's going 2 or 3 steps beyond what I'm even talking about, and that's absolutely correct. The nuance part of it is always the argument when you're talking about using AI versus using an experienced lawyer in a particular field. But even before you get to that, there's just so little input available for AI to draw on, especially in Canada, that there's no way for the AI to give you an answer that you can rely on. You just can't do it. So the Pocket Disability Lawyer, which you can find on our website, that's not based on AI at all. That is based on our experience and based on us mapping out all of the various scenarios that you might be faced with. Now, this isn't going to give you nuanced advice either. That's just not something that we believe a computer is capable of doing at this point in time. But what it is going to do is start funneling you into whether or not this is something that you should take another step on or not. And at that point, you can make a decision whether or not you want a free consultation. And if so, you can decide to give us a call or not. It is entirely up to you. There's no risk to using it. But again, if you are interested in having some insight into whether or not you have a case, it's Pocket Disability Lawyer.
.ca, that's where you find it. James is right. Also, you can go to disabilityrights.ca. We do radio shows pretty much across the country, almost pretty much all over the place during the week, weekends. And go there to find a station near you that carries our show. James hosts a bunch of them. Got our first phone call from the show. James, let's listen to it, break it down, and learn from it. Here we go.
I've been employed for almost 20 years. I was on short-term disability, and recently my boss told me to apply for long-term disability as I still can't work. I'm still waiting to hear back, but I'm not sure how this will go. Will approval be automatic, or should I be prepared for a denial?
It's a really good question, and so I want to put this into context here, because this particular caller, what you need to understand is she's transitioning from short-term disability benefits into long-term disability benefits. What I don't know is how her short-term disability benefits are structured. There are 2 ways that can happen. The first is where your employer is actually paying for the benefit, and then they hire another company to administer the benefits, to get your medical information and to look at it and make decisions about whether or not you're entitled to those short-term disability benefits. The other scenario is they just have an insurance company that they pay premiums to, and the insurance company does what insurance companies do. They take in all of your information and they process it and decide whether or not to pay out the benefits. So those are the 2 different ways it can work. And the reason I'm making this distinction is because when you're transitioning from short-term to long-term disability, it matters whether or not whoever made the decision for short-term disability is the same entity that is making the decision for long-term disability. If you have insurance for short-term disability, if it's not being paid by your employer, typically you're going to see the same insurance company insure short-term and long-term disability. If you have your employer paying for it, you may have the same entity that is insuring long-term disability administering the short-term, or it may be someone completely different. And that's really where the difference lies. If you have a different entity making the decision for short-term disability benefits, then there's no particular reason why you should be at all confident that an approval for short-term disability is going to lead to an approval for long-term disability as well. 2 different entities making the decision, they can very easily come up with 2 different decisions at the end of the day. And keeping in mind, the short-term disability insurer is really only looking at typically 3, 4, maybe 6 months, whereas a long-term disability insurer could be looking at years, even decades. And so they have a much greater incentive to find some justification why you may not meet the test for disability. But the thing of it is, the test for disability in short-term and long-term disability is functionally the same. In substance, if you look at the language of the test for short and long-term disability, it comes down to whether or not you have a medical condition that's preventing you from being able to do your own occupation. Now, if you are approved for LTD years down the road, that test will change, but if you're transitioning, the test is the same. And so if you have one entity that is making a decision and says, yes, you are disabled from your own occupation, it's very difficult for that very same entity, that same insurance company, to then say, okay, but now that we're in long-term disability, you no longer meet that test, because the test is functionally the same. If you have different entities, they can well come up with a different result. Now, all of this is to say, if it is the same, there is a greater chance that you are going to be approved for long-term disability, but by no means is that a guarantee. I have certainly seen many, many occasions where it's the same insurance company making a decision on short-term disability, and somehow, by coincidence, on the very day the person is entitled to start receiving long-term disability, the insurance company says, oh, you no longer meet that test. What a coincidence, but it happens. That said, it is still much more likely, if it's the same entity making the decision for short-term, that you will be approved for long-term disability.
And if she gets a denial and they ask her to appeal, which will probably happen, what do you do now?
You don't appeal. Listen, the appeal is going to be a waste of time. The appeal is just set up to avoid you going through the litigation process, not for your purposes, for the insurance company's purposes. And why? As soon as you have a denial on your disability benefits, there is a 2-year limitation period, and that clock starts running the day that they write the letter. If you go through this appeal process and you're not approved, and there's no reason to believe that the same entity that is disregarding what your treating doctors are saying about your inability to return to work is all of a sudden going to change their mind, if you are appealing to them, there's no reason to expect they're going to change their mind. And once they maintain their decision, write you that letter after a month or two saying, we're not approving your appeal, they're probably going to give you an opportunity to appeal again. And the object here is essentially to run out the clock. If they run out the clock, if they take more than 2 years in this process, or the second or the third or the fourth process, and I've seen that happen, then you're out of luck. There's nothing you can do about it. So give us a call. There's no reason to waste time in the appeals process. The sooner you start litigation, the sooner it resolves. And at the end of the day, if you're not getting your benefits, you want to make sure that you start that process as soon as possible to limit the amount of time that you're not getting the benefits that you obviously are going to need.
We are going to take a short break, so stay with us. On the return, it is Don't Be Pressured Back to Work from LTD, protecting your rights. That is the main topic as we continue the Disability Law Show, so hang in, we're coming right back. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Alrighty, welcome back. Disability Law Show. I want to remind you, you can reach out to James and his team anytime. Consultations won't cost you a thing. If you just need a chat, some information, phone numbers 1-855-821-5900, help at disabilityrights.ca. Okay, main topic time, James. Don't be pressured back to work from LTD, protecting your rights. Number one, who should provide approval for a return to work plan? Who's that going to be?
Well, I can tell you who it's not.
Right.
It should not be your insurance company,
right,
nor should it be your lawyer, by the way. If somebody calls me and asks me, when should I return to work? My answer is, well, what does your doctor say? I'm not here to provide anybody with medical advice. It's just not my area of expertise. And so if you call me and ask, that's what the answer is going to be. It's not up to me to make that decision. The two people that you should be relying on in order to make the decision about when to return to work, which is a medical decision, the two people you should be relying on are your doctor or specialist or treatment provider, if it's a therapist, whoever your primary care provider is for your particular disability, that's who you should be relying on from a medical perspective. Am I okay to return to work? Am I medically fit? Is it going to be dangerous for me to return to work given what my disability is? Am I going to set my treatment and recovery back if I try to return to work now? Or should I continue with the treatment as is and try back in a few months? The second person you should rely on is yourself. You are the best person, given what you know from your doctors and how you feel, your awareness of your own body, of your own mental state. You're in the best position of anybody to understand whether or not, if you try to return to work, it's likely to be successful. And you have to trust your gut. You have to listen to what your body and your mind are telling you. And if you're optimistic about returning to work, if you feel like it's something that you can do, well, then you're in the best position possible to do it. If you believe that you're going to be able to do it, I can tell you, at least anecdotally, it's my experience that when I have clients come to me and say, I think I can go back to work, I say, well, then talk to your doctor and make sure they're on board. But as long as you're feeling optimistic about it, that's usually the best indicator that you're going to be successful. So if you feel like you're able to do it, then that's great. Talk to your doctors, and as long as they're on board, then you're in a great position to do it. But on the other side, if your insurance company is saying, we feel like you can go back to work, and you do not feel like you're capable, you feel like, no, I have difficulty getting out of bed, I'm not able to focus on anything for 10 minutes, I can't sit for more than half an hour, whatever your functional limitations are, if you know that on a day-to-day basis that it's unrealistic that you're going to be able to maintain a regular work schedule and be productive, if you know that you're not ready now and your insurance company is pressuring you to do that, then it's incredibly unlikely that a return to work is going to be successful. In that scenario, again, talk to your doctor, tell them what you're feeling. It's unlikely your doctor is going to approve in that scenario. And as long as your doctor agrees with you, you want to put that in writing and submit that to the insurer.
So as far as the insured, James, or your employer, is any sort of necessary documentation that should be provided in this case?
Absolutely. So if this is the insurer's idea, if the insurer is saying, all right, we think you're ready to return to work and we're going to stop paying you your benefits in 3 weeks, which is going to be your start date. What you want is, first of all, to get that opinion in writing. You want to make sure that you have that clear black and white that the insurance company is saying that they believe that you're ready to return to work. What you also want is written confirmation of what your work schedule is going to be. Typically when this happens, there's what's called a gradual return to work. And so it's usually a schedule where you start off by working 2, maybe 3 days a week, half days to start with, and then after a week, maybe 2, you go up to 4 days and then 5 days, and then from half days to 3/4, and then hopefully eventually to full time. That's a typical progression. It could take 8 weeks, it could take 16.
Sure.
Really depends on the circumstances. So you want that. You want what that plan is. You want to have that in writing. And the other thing you want is what the proposal is going to be in terms of any accommodations you're going to have, whether there's going to be any restrictions or limitations in terms of your regular job duties. That's typically going to be done in conjunction with your employer. You want to get all of that in writing, and then you want to submit that to your doctor, usually your GP. But if you have a specialist that is your primary care provider for your disability, submit it to them and have them review that material and ask them whether or not it is reasonable for you to do this. If they believe it is, and you're at least reasonably confident and that you might succeed, then by all means, go back to work. If you're able to go back to work, that is the best thing for you. But if your doctor believes that going back to work in the circumstances outlined by your insurer is not going to be successful, and more to the point, is going to be harmful to you, it's going to set back your treatment, set back your recovery, then you need to make sure that you get that opinion in writing, in black and white, from your doctor and submit that to your insurance company. That's going to do 2 things. One, once they have that medical opinion that's reviewed their plan by a medical doctor and says this is not only inappropriate, but it's actually dangerous, it can actually harm your insured, the insurance company is not going to have a choice but to at least reconsider what they're proposing. Now, that does not mean that when reconsidering their proposal, they're going to change their mind. They usually don't, but they're going to have to at least take a look at it. If they happen to change their mind, problem solved. Then you don't have to worry about going back to work on their schedule. You can do it when your doctor and you believe that you're okay to do it. But if they maintain their decision and say, no, we've read what your doctor says, we disagree, you're going to have to go back to work. Well, at the very least, in having put that in front of the insurance company, if down the road you wind up starting litigation, your insurance company is not going to be able to say, well, we didn't know it was going to be dangerous. We didn't know that we were putting you in harm's way. They'll know that. And if a judge looks at that and agrees with your doctors, the insurance company has just exposed themselves to a finding of bad faith, which means punitive damages, which means if you start litigation, your insurance company is on the hook not just for the benefits that they should be paying, but also for a potential award of punitive damages, which can be very costly for insurance companies. So if you have to start litigation, you will be in a much better position if you get your doctor to look at the plan and comment on it.
So assuming you have doctor approval, medical approval, you're feeling okay inside your own head, your own body, you go back to work, oh, pulled the trigger maybe a little early, I'm not ready for this, maybe I should be off again. Can you resume benefits, or is that going to be a problem?
If you look at the policy, there's what's called a recurrence provision in any standard long-term disability policy. And all that essentially means is that if you attempt to return to work, and usually there's a time limit, typically it's 6 months. So if within 6 months of an attempt to return to work, you become disabled from work again for the same disability that caused you to go on leave the first time, the policy says that you're entitled to resume your benefits as soon as you go back on leave. Now, the idea behind this is the insurance company doesn't want to make it difficult for you to try and return to work. They want to encourage that, and so they put this provision in there so that there isn't a penalty in attempting to return to work. It's not as though if you return, you're automatically cut off forevermore. Having said that, in practice, what we find is typically the insurance companies, once you've attempted to return to work, if you have a recurrence, it's unusual for the insurance company to then say, okay, we agree, you're entitled to get your benefits again. Typically in that case, they're going to say no, which means you're going to start litigation. All of which is not to discourage you from trying to go back to work. Again, if your doctors are on board and you're optimistic, absolutely try, but if you're not, then you shouldn't be doing it, because if you do attempt to return to work and you're not successful, you're going to get cut off anyway. So listen to what your doctors are saying.
With that, we'll get into one more short break and come back with a phone call, some emails, and some other questions. So stick around. Disability Law Show rolls on, and we're coming right back. Stay with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Disability Law Show. A few minutes to go. Beyond that, reach out to James and his team. We always tell you to do that. If you just have some questions, consultations won't cost you anything. The number is 1-855-821-5900. Back it up with an email, help@disabilityrights.ca. Same website to go to as well, disabilityrights.ca, to find a radio station in your hood where you can catch our show. They're usually about an hour long and informative, just like this one, over the airways. Again, phone calls from the radio show are fantastic. James, second one for today is coming up right now, so listen up.
I've been on long-term disability for a year and a half now. I was told that I would be reassessed to work in another position. I don't know how this is possible and what I should do next. It's been weeks since I sent over some medical reports and I haven't heard back. I'm worried they're just going to cut me off.
Well, it's a common problem, and so this is a function of where this caller is in the process. Yep. So when you get approved for long-term disability, after 2 years in a typical long-term disability policy, after 2 years of being approved for LTD benefits, the test that's used by the insurance company changes. For the first 2 years is whether you have a disability that is preventing you from being able to do your own occupation. After 2 years, that changes to whether you have a disability that is preventing you from doing any occupation that you're qualified for by education, training, or experience. Now, that is a tougher test to pass. It is certainly a broader range of occupations that they will be looking at. And so what we see quite commonly is when someone is in the position of this caller, when they are nearing that 2-year mark, you see the insurance company gearing up to justify cutting off benefits at the 2-year mark. Now, it doesn't always mean that that is going to happen, but they are going to take a look at it. And so they're going to want to ask you about your education, about your training, and about your experience. And then they're going to look at what are the other occupations that you might be medically capable of doing that you're qualified for. And for a lot of people, that is a very difficult process to accept, especially if you've been with your employer for years or decades even. And the idea that your insurance might be cut off if you're qualified to do some other occupation, even if it's entirely unrelated to what you're doing right now. But that's the reality of how the policy works. That is the way the contract works, and that's all the insurance company has to do. Now, just because they say that you have another occupation that you're able to do, doesn't mean that they're right. Even if they tell you, okay, well, sorry, but we believe that even though you are a doctor, now you can be a greeter at Walmart. And that is not by any means to denigrate greeters at Walmart. But the distinction I'm making here is there is a very wide disparity in what you might earn as a medical doctor versus what you might earn as a greeter at Walmart. That's just a fact. And that is relevant because even if your policy doesn't have specific language talking about what you would need to be able to earn in this any occupation period if the insurance company says you can do another occupation, the law says that there is actually something that you do have to look at. And if the policy is silent, it says nothing about what you would have to be able to earn, a judge looking at it is going to say, well, even if there is some other occupation you can do, unless it's going to pay something in the range of 60 to 65% of what you had been earning before you went on medical leave, then it's insufficient. The insurance company can't rely on that and say, okay, you can be this greeter at Walmart and therefore you are no longer entitled to benefits. They have to find something that's going to pay you what they call commensurate income. That's the phrase that they use. Some policies actually do specifically outline what that commensurate income is. Usually when we see it, something in the range of, again, 60, 65%. I've seen as low as 50, I've seen as high as 75. But more often than not, the policy is just silent. And when it's silent, it's looking at something in the range of 2/3. A good rule of thumb is if you are not able to do another occupation that would replace, in most cases, the income that you're getting from your LTD benefits, if you can't at least replace what that income is in most cases, that means that you are still disabled under the policy and that you're still entitled to continue to receive benefits.
Do they have the insurer have the right to, in this case, if you don't know how to, go out and train you how to be a Walmart greeter? Like a different position? Can they say, well, you look like you qualify, but just brush up on these skills?
Well, so, that's a really good question. So oftentimes if the insurance company is being proactive, and they're often not, but if they are, they might take a look at what additional training and expertise do you require in order to be qualified for this other occupation. And if they're really ahead of the game, they will say, okay, 3 months before the change of definition, we're going to pay for you to take this training course to improve your computer skills, for example. That's always a big one, especially if you have someone who is doing a physically oriented job and there is a sedentary job that they might be qualified for if they can upgrade their computer experience. So a lot of times you'll see the insurance company say, okay, we're going to pay for you to take this computer course for the next 3 months. At the end of those 3 months, you're now going to be qualified to do these other occupations. And in many cases, that might actually be correct. Might not be, and it's really going to depend on what your functional limitations are. If you are in that scenario, the best thing to do is give us a call. It's a free consultation, and we're going to be able to walk through all the different scenarios and all the different factors that go into whether or not it's a correct decision and guide you towards where you should go, what you should be doing, and whether or not starting litigation is the right choice.
But even with that, now that we're wrapping up, they cannot sidestep the commensurate income piece?
No.
Okay.
No, they still have to find something that's going to pay you commensurate.
Gotcha. And we're done for a show. That happens quickly, but thanks to you, your phone calls, your emails, and everything else. Keep them coming. We'll get them on the next show. In the meantime, reach out to James and his team. The phone call and the consultation won't cost you anything. 1-855-821-5900. That email is help@disabilityrights.ca. If you want to know if you should even call James ahead of time, that's go to disabilityrights.ca, right? That's where you want to go. We'll catch you next time on the Disability Law Show. Take care. Thank you so much.